Afternoon. Is this working? Yes. Good afternoon. And before I proceed, we acknowledge that we are meeting on the traditional territories of the Mississaugas of New Credit, First Nation. My name is Janet Miner. I'm Treasurer of the Law Society, and I'm delighted to welcome you to our annual event in celebration of Asian and South Asian Heritage Month. And I'd particularly like to thank our partners, our longtime partners and supportive partners, the Canadian Association of South Asian Lawyers, Federation of Asian Canadian Lawyers, and the South Asian Bar Association for organizing and co-hosting today's event. We're very grateful for the partnership and the collaboration you've displayed to us and with us in helping to promote equity and diversity and access to justice in the professions. Throughout the year, for those of you who haven't attended before, our Equity Initiatives Department organizes public events like this, which involve symposia or panel discussions with our various legal communities to celebrate events. For instance, Black History Month is another one, and to create dialogue amongst the Law Society and our other communities about the rights and needs of equity-seeking lawyers and paralegals. We are committed to enhancing equity, diversity, and inclusion in the profession and to eliminating barriers to entry and advancement for those groups. We know that we're not there yet, that further gains need to be made. And I think probably most of you by this point are familiar with our project entitled Challenges Faced by Racialized Licensees. Since October 2012, our working group has been meeting with lawyers and paralegals across the province and has been working to identify the kinds of challenges that are faced by them, and ultimately to develop proposals that we can enact to help eliminate some of those barriers and result in conclusion for those people at all stages of their careers. And we released a consultation paper in 2014. Following the release of the consultation paper, more meetings were held again in various parts of the province and with various representative groups, law firms, individuals, and students. And again, a tremendous amount of very positive feedback was received. So at this point in time, the working group is working on their final report, and with recommendations that we are expecting would get to convocation in the fall. And at this point, still looking for input and further input from this panel and through your questions and responses to it. And I have to say that the final report will be considered by a different convocation than we've had in the last 4 years because of the recent bencher election. And I wanted to say I was really gratified to read the election statements by all of the candidates in the election because there were few, if any, who did not refer to their support for equity, diversity, and inclusion in the profession. And I wanted to also pay a special thank you to our partners, our partner organizations today, because they helped promote and support candidates for election, and I think they did a very good job in also engaging their members and urging them to vote. And it's through voting that we have a lively and reflective convocation that can serve our members best. So I thank you for that too. So thank you again for joining us today, and let's continue. I'm not sure who's supposed to follow me. That would be okay. Lai-King, thank you. President of FACL.
Thank you, Janet. I want to thank you, Janet, and also to congratulate you on your re-election as bencher and treasurer. You have always enjoyed the confidence of the diversity associations. Thank you to the Law Society as well for its role in promoting equity and diversity. It is my pleasure to be your master or mistress of ceremonies. My name is Lai-King. I'm president of the Federation of Asian Canadian Lawyers, and I'm also chair of the Roundtable of Diversity Associations, RODA. RODA is an organization of diversity-seeking legal associations, which includes FACL, SABA, and CASAL, the organizers of today's event. So welcome, everyone, to today's Asian and South Asian Heritage Month event. Welcome. Bienvenue à tout le monde. 欢迎大家. Namaste. So I say these welcoming remarks in various languages because this morning, as I was thinking about what I was going to say today, I hadn't prepared it, and I had quite a bit of work to do before coming here today, and I was thinking, well, what am I going to say? But I was also listening to the CBC, and the CBC had Patrick Brown, the Conservative MP from Barrie, who took the leadership of the Progressive Conservatives for Ontario. And no matter what you think of his politics, he did feel that it was very important in his thank you speeches to address the audience in their native languages. So it gave me pause. Here is a politician who felt it was very important to address a racialized demographic. His thank yous included a thank you in Mandarin, in Tamil, various other languages. And it made me think that politicians today need to factor in the racialized voter if they want to win. And the strength of the racialized voter was also evidenced in the bencher elections, where the racialized vote counted, and we have now a convocation which is a little bit more reflective of the lawyers that it regulates. So it made me think, well, it looks like we've come a long way. So today is a celebration, in a way, of how far we have come. And it's heartening for me to see so many people here to celebrate the South Asian Heritage Month event. But to me, it's also sad. It's sad because it's 2015 and there's still work to be done. It shows that there is still a need to make things better in the legal profession. And as the treasurer mentioned, the consultation report revealed that there was a lot of challenges that are still faced by racialized lawyers. We see a clear disparity between the population that is served and the lawyers that appear to serve the population. The very trajectory of our respective legal associations tells a story about our relevance. FACL has grown from its roots in 2007, from the first 75 attendees to our first annual conference, to our current 750 members in Ontario and growing across Canada. We have a chapter in Vancouver, Calgary, and in Halifax. SABA, the South Asian Bar Association, has a similar story. It started around the same time, I believe, as FACL, and it too has grown exponentially over the years. CASAL has a solid base outside of the Toronto core. The fact that these organizations are growing and are demanding that their voice be heard indicates that there is a lot left to be done. Last year, we had, during this event last year, the same topic was up for discussion. The carrot or the stick, how to achieve diversity. We had representatives from the Legal Leaders for Diversity, a law firm representative for diversity and inclusion. We had a community leader for corporate diversity, all speaking on this panel. Today, we have a follow-up discussion, and the follow-up discussion is particularly relevant because of the consultation report that was released in October of 2014, last year. The panel today will discuss How do we achieve diversity? And have we made any progress? I'm going to now introduce you to our distinguished panelists. I'm going to start with Jayashree Goswami, who is our moderator for this evening, and she's right here, my immediate left. Jayashree is the current president of the South Asian Bar Association Toronto, and she has been involved with SABA since its beginnings. She is an insurance defense counsel for Zurich Insurance of Canada, and prior to this, she practiced commercial litigation at a Bay Street law firm. Next to her, I have Manfred Lam. He is the Deputy Chief Compliance Officer in the Canadian Personal and Commercial Banking at BMO Financial Group. Prior to this role, he was Senior Counsel supporting BMO's commercial line of business. Manfred is actively involved with the legal group's Diversity Council, and he currently serves as co-chair of the Community and Stakeholder Engagement Committee. Next to him, we have Wesley Ng. Wesley is a partner at Stikeman Elliott. He is the head of the firm's technology practice group, and he was recognized by the best lawyers in Canada in 2015 for his expertise in information technology law, and by Chambers Global's Guide to the World's Leading Lawyers for Business 2015. That's congratulations. More importantly, he is also the founder of the Diversity Committee at Stikeman's, one of the founders. We have, next to Wes, we have Andrew Pinto. Everyone knows Andrew. Andrew is a partner with Pinto Ray James in Toronto. He practices in the areas of civil litigation, employment and labor, and administrative law. Andrew has been recognized in Best Lawyers in Canada and for administrative and public law, and as a leading practitioner by the Canadian Legal Expert Directory in the areas of workplace human rights. In addition to his litigation practice, Andrew conducts workplace investigations on behalf of organizations. Andrew is here to speak about diversity from the small firm perspective. Next to him, we have Malliha Wilson, and she is Assistant Deputy Attorney General, Legal Services Division at the Ministry of the Attorney General. She is the highest-ranking racialized lawyer in the ministry, and it's wonderful to see you here. Malliha is, prior to being appointed as the ADAG, she was the legal director at Crown Law Office Civil, and before that she was legal director at the Ministry of Labor Legal Services Branch. Thank you everyone for being our panelists, and I will now cede to Jayashree to introduce the discussion. Thank you.
Thank you, Lai, for that very warm introduction. After hearing Lai break out into so many different languages, I feel I must show off my language skills. Funnily, the only other language I kind of speak is Spanish. So, buenas tardes, amigos. I'm delighted to be moderating today's panel discussion. Today's topic is called Carrot or the Stick: How to Achieve Diversity in the Legal Profession. Now, while this topic has been the fodder for many conversations, discussions, and debate before this, the topic is of special relevance today. As you heard from Treasurer Minor, over the last 2 years, the Law Society has undertaken a comprehensive and a probing review of the challenges faced by racialized lawyers. The official results are in, and they're scathing. In a nation where diversity rather than numbers defines our strength, we as a profession remain conspicuously, critically behind. And this isn't a problem for racialized lawyers only. This is a problem for and of all lawyers. Today's discussion is of particular relevance because more people than ever before in this profession are talking about and committed to making a change. And this initiative is being led by none other than our regulator, the Law Society. Someone once said that the right thing at the wrong time could be the wrong thing. But ladies and gentlemen, this is not only the right thing, but it's the right time. To contextualize this discussion, I want to provide a brief background of the initiative that the Law Society has undertaken over the last few years. In August 2012, the Law Society created a working group which was called the Challenges Faced by Racialized Licensees Working Group. The working group was tasked with an ambitious mandate to identify challenges faced by racialized licensees, to identify factors and practice challenges faced by racialized licensees that could increase the risk of regulatory complaints and discipline, to consider best practices for preventive, remedial, and support strategies, and if appropriate, design and develop preventive, remedial, enforcement, and other strategies. Between August 2012 and October 2014, when this consultation paper was published, the working group has been very busy. It has conducted a review of all the data and literature and the studies that had already been conducted on these issues. It has met informally with a number of individuals and organizations to obtain viewpoints on challenges faced by racialized licensees. It has worked closely with the Equity Advisory Group and a working group within the Equity Advisory Group. It has retained the professional services of Stratcom to formally engage with the profession. This engagement has included 20 key informant interviews, 14 focus groups with racialized licensees, 2 focus groups with non-racialized licensees, and a 35-question survey conducted within the profession, which I hope many of you responded to. It's also created a parallel engagement process, which was called the Community Liaison Process, to gather information from racialized licensees who may not have come forward during the Stratcom report. The consultation paper findings were that racialization is a constant and persistent factor affecting licensees at every step of the profession. And a majority of the participants in the Stratcom engagement process, both racialized and non-racialized, agreed that the challenges faced by racialized licensees have an impact on the reputation of the legal profession, access to justice, and the quality of services provided. So once again, ladies and gentlemen, I reiterate that this is a problem not just for racialized licensees, but for the profession as a whole. The consultation paper has put forward a number of specific questions to the profession. And in the course of today's panel discussion, we hope to explore some of these questions and to debate and discuss what would be the best strategy moving forward. So without further ado, I'd like to jump into the discussion. My first question being, this consultation report that we have all reviewed, what is the significance of this to the profession? Have we learned anything new? Is there anything that surprises us, or have we seen it all, heard it all before? Starting with Manny.
Thanks very much, Jayashree. I think from my perspective, there's nothing really surprising about it. I think, as you described, it's scathing, but I think those of us that belong to the racialized minority or racialized licensees groups has probably seen it in our profession, whether it's the barriers to entry, whether it's the advancement within either in private practice or in-house position. But what I think the significance of this report, and I do think it's an important piece of work, and I really do commend the Law Society for starting down this road, is that it starts the discussion. But there's a huge question that carries on from that report, and that's what next? And what are we going to do next? What's the Law Society prepared to do? And what are their final recommendations going to be? So I think we all are watching anxiously to see what these final recommendations are going to be, whether the recommendations that a lot of the focus groups have provided, all the input that people have provided, whether those are going to be taken into account, and whether really there are going to be some substantive, meaningful actions being taken by the Law Society.
Right. Do you think that one of the benefits of having a report like this is that it's a historical document. It's kind of a report card on the profession at a particular point in time.
So, just to respond to something, I generally always agree with Manny, but one thing I would say is, I don't think that this report, as Manny initially said, this report is, I think, reflective of everybody's expectations of what the findings would be. And I don't think it's actually going to initiate a conversation. I think this conversation has been initiated well over a decade ago, 2 decades ago. Certainly my visibility is probably limited to the big firms, but certainly within the big firms, there's not a whole lot of racialized diversity. And I would have to say, we initiated our diversity committee in 2001, and I think since then, and even maybe before then, a number of other firms had done the same, all because we'd recognized that there's this issue. And I do think it's an issue, as you mentioned, that all lawyers want to address, because I think we all appreciate that a diversity of perspectives will only help improve the talent pool. It will only help improve the advice that we give to our clients. But the issue is, and the issue I think has been since 2 decades ago or what have you, how do we get to where we need to get to? Right. And I think that's what we've been struggling with. And I guess one of the concerns that I had with the report was that that's what's missing. So I knew that there was an issue there, and I think a lot of us did appreciate the issue was there. We're looking for the solutions.
Right, and we're here to talk about the solutions today. So let's talk about that. One of the questions that the Law Society has posed to us is, what can the Law Society do to assist with establishing diversity programs within firms, organizations? Let me back that up. Should the Law Society be involved? Should the Law Society lead? Malliha?
I think that the answer to that question is not quite apparent yet. I would say that just to go back to the earlier question and not follow the rules, in terms of this report, I think the significance of the report is that it gave voice to this issue, right? And while previously it had been talked about, and there would be panel discussions, and people like us would be on the panel, and then nothing further happened. So this, I think, is a really good first step. But I agree with it all depends on what happens next. And that, I think, will inform who should lead the debate and the further implementation of the recommendations in the report and so on. But also, I think it's important that the aspect of voice be respected. So this report speaks to racialized licensees. And who should speak for racialized licensees is, I think, a really important question.
So I think I'm going to, you'll hear me, for the most part, opt for solutions more about sticks than carrots, and that's part of it because I don't like carrots, and because carrots are
Nobody
soft.
likes carrots.
Carrots, especially when they're boiled, are soft and mushy, and don't always satisfy you. But I mean, my experience is informed. I'm at a small firm, and you're also going to hear me suggest that small firms and medium firms have a huge role to play, and this idea that large firms should lead or large firms should only have the resources is incorrect. I was glad to see my managing partner of my law firm here, because he knows and I know we spend a tremendous amount of time at our firm focused on retention, promotion, discussing equity, and the truth is, and many of you will experience this, the truth is that it's not easy. So it requires a focused, sustained discussion. I think that there is really, when you think about all the options, you'll come back to the Law Society. I think this report is important. I think it's critical because the Law Society, your regulator, did it. It was done by an institution that is, let's face it, largely led by white people, white men. I'm happy to see some impressive changes in the recent election, and I congratulate those racialized candidates that run, and whether they won or not, that was a huge improvement. So I'm an optimist. I think the Law Society has done an important thing. I think we have to have a certain degree of regulation to make any difference.
Andrew, you said something interesting. You said it's not easy to remember to talk about these issues.
Right.
Why is it not easy? And what can be done to make it kind of more part of the curriculum, so to speak?
Right. So the reason why it's not easy is because at the end of the day, you are dealing with human beings, and we all have just slightly different attributes. And whether you're talking about promotion or retention, you are really trying to measure different attributes, and we all want the best articling student, partner, associate, and I think that we can have those things. There is no, I think we all recognize up here, and many of you there is not this divide between merit and equity, but understanding how those work together is a complex phenomenon. That's why I am an advocate, for the most part, for cultural competence being led by a regulator. I am in favor of mandatory aspects of demographic measuring. A little bit later on, I'm going to be talking about what's being done across the pond in the UK and England and Wales, and some incredible steps that have been taking place since 2009. So, we don't have to keep on scratching our heads and wondering, how do we do this? There are models of how it's being done well in other jurisdictions.
So I'm just going to reply to that because I have a very different perspective, which is what we want. So my perspective when it comes to a carrot or stick is I think you have to incentivize organizations, whether they be small or large, to really appreciate the benefits of a diverse pool of employees. And unless you have people invested in the solution, I don't think you're ever going to come up with an appropriate solution for racialized communities. I think if people are becoming more diverse because they feel they need to become more diverse, then you're going to find that it becomes more of a two-tier system. I think, at least what I'm hoping in my firm, the issue of diversity, I think, has now become part of the culture. So I don't think it's as difficult to have the conversations about it. In fact, the conversations happen because it's part of our culture. So when you have a conversation about something, you raise issues about diversity. We're going to have a panel. Oh, you know what? The panel doesn't seem to be properly reflective of either the audience or the lawyers. Let's do that. So again, and these are discussions that happen because it's part of the culture, not because if the Law Society comes and says, we want X percentage of your population to be X, okay, we'll do that. But, that's what we'll do, and we're not going to necessarily invest in those individuals because really they're just fulfilling a quota, as opposed to we are completely invested in those individuals because they bring, an element into the discussion that we wouldn't otherwise have. So.
Right. Now, the four of you are from very different kinds of organizations, the government, the smaller firm, the larger firm, in-house. You don't have a one-size-fits-all thing going, right? So I'm going to start with you, Manny. How do you incentivize the fostering of diversity in an organization such as yours? And I'd like to kind of hear from everyone across the board.
Well, I think one of the important things that happens at BMO is that we have the tone from the top. So Simon Fish, our general counsel, he's very involved in the diversity initiatives. He's one of the members of the Legal Leaders for Diversity. So he understands the importance of diversity. And one of the things he says to both us as an organization and also to other organizations, which he deals with, is there's no longer a discussion about whether diversity is beneficial to an organization. That discussion is long in the past. let's move on from that and let's move to how we're going to make changes, effective and meaningful changes in organizations. So starting from the tone from the top, Simon is very clear on his commitment to diversity. I think moving down from there, there's a trickle-down effect. Once he demonstrates that commitment, all of us also feel his commitment, but he also empowers us. So we have a diversity council that is employee-led, and we're all empowered to come up with our own diversity initiatives. So some examples have been that we have come up with like a supplier diversity program, which encourages and invites all our law firms to disclose diversity statistics for the law firms, and we use that as one of the measures for in the RFP process of which law firms that we choose to work with. Another example is reaching out to particular community organizations that individuals within the legal group have an affinity with or some sort of connection with too. So that's the kind of feeling I think, at least in a large organization, we need to have the leadership support, the senior leadership support, and I think that commitment trickles down to the rest of the employees. I think that's just one of the many ways that we encourage diversity at a large organization.
Right. Malliha, what about the government?
Yeah, I think certainly the commitment has to be top-down. If it's not, it will be very difficult. But then once it's top-down, then there has to be a resulting movement from the bottom up, because it's very hard to sustain it otherwise. And it has to become the new normal. And it has to be seen as beneficial, not just, I think, from a business point of view, but from a cultural and social aspect, because, especially in the legal profession, lawyers work so many hours at their work. And if it's not part of the fabric of the workday life, people, it will lose its allure. So, for example, now I have to tell you that the difference between, say, I would say 8 years ago, 5 years ago, and now in our organization is that we have a fairly large number of racialized lawyers. And people, so for example, if they're South Asian, the people talk about how many weddings they have to go on the weekend, right? But it's no longer strange to hear that conversation. It is part of the conversation. You can have legal teams that are now all racialized lawyers. That would have been unheard of 5 years ago. So the commitment, in my view, or my experience really is from the top down, but then you build from the bottom up. And just from a personal experience point of view, there is nothing better than having companionship. So more recently, just recently, I think a month ago, we had at the Assistant Deputy Attorney General level at the Ministry of the Attorney General, Kimberly Murray joined us, who is Aboriginal. And, it makes a difference. And what that brings in is an additional perspective, I think, which is what we talked about, as to how to view the issues that are before you as a lawyer or as a senior executive, and what's the lens that you put on to, in essence, problem solve, right?
Right. I'm going to go to you, gentlemen, from private practice. It seems to me from Manny and Malliha's responses that having a leader who is invested in diversity is an important first step. Now, that is often missing in private practice, either because a firm may be too small or it may be too big. So now we have you, Wesley, from one of the largest law firms in the country. What's your perspective on this?
Well, I think in order for any firm to really be successful, there has to be a commitment to the individuals that make up the firm. So with us, the diversity initiative was really it was a grassroots initiative started by 3 associates, me being one of them. And we basically we wrote up a report and gave it to the managing partner, and the managing partner took about 3 hours to read the report, came back and said, what can I do? what resources do you need? Well, we need a lunch budget for sure. So it really just grew from there. So I think management, and I think this will apply with a lot of firms, right? Because the firms really do invest in their people. That's their talent. So when we told the firm that there's this issue, and the issue was really this amorphous issue of not an actual issue of, oh, there's racism here, but an issue of, well, look at the numbers, right? How come our firm, the partnership at our firm is not necessarily reflective of the associates, and the associates are not necessarily reflective of the community that the associates are drawn from? And so the firm came back, and the managing partner was very committed to it, struck up, as firms are wont to do, a committee, a formal committee, but they really gave everybody who was part of the initiative a lot of power to do what they wanted to do to help improve the situation. So Manny had talked about community service, which I think plays a really big role in not just diversifying the firm, but diversifying the bar, right? Because I was talking to Cable about this recently, and we were looking at a particular law school, and there were almost no black lawyers at that law school. So how do we actually address the talent pool that's coming out of certain law schools in order to make sure that they're there for us to bring on? And so we started, and this is because of a connection I had, a connection with Pathways. So I have to promote Pathways here. So Pathways at the time was only a Regent Park group, and so we established a partnership with Pathways where we initially started by just bringing in these grades. So Pathways is a community group in Regent Park that was intended to help or encourage kids not just to stay in school, but actually to seek post-secondary education. And so we brought these kids in at grade 9 and grade 10 to just give them a tour of the law firm, introduce them to diverse lawyers to show them, hey, guys, this is an option for you. And then after that, I think in the next year, we started another program where we were bringing 2 people in every year. Law firms have these great summer positions that are often given to clients of clients' kids who don't really need that position. And we thought it'd be a really great opportunity to give it to people who otherwise wouldn't actually be able to access that environment. And we've been really successful, and we've hired our first Pathways graduate to come in as an articling student this year. So, so I think one of the things you really have to do is invest back into the community to affect the change that you want to see.
Right. It's apparent to me that you had a receptive audience. What if you don't, Andrew?
Yeah.
Smaller firms.
I want to address that topic because one of the things I did last night was I chose a couple of well-known litigation boutiques, and I'm not going to say which ones, but there weren't a huge number, but these are well-known litigation boutiques. And out of 227 lawyers, and what's great now is a lot of these law firms have all the pictures, right? So, I mean, yes, I could be wrong. It wasn't a scientific survey, and people could self-identify as racialized, and to me, they looked otherwise. But 227 lawyers, 9 or maybe 8 were racialized. That's less than 4%. And I know many of the lawyers at these firms, and it really made me wonder I would love to talk to the managing partners at these firms or some of the lawyers at the firm, and I probably will, and say, are you aware that you have an all-white firm? I mean, one of them is 1 out of 32. The other one is 0 out of 23 lawyers, 1 out of 51 lawyers. And when you look at it's all white, male and female lawyers. I'm sure they're wonderful people. They're well-meaning. They may not appreciate the lack of diversity at their firms, but it made me wonder, in private practice, is there even an awareness at some of these firms that they aren't diverse, and what can we do about it? So I congratulate Wesley's firm, and I'm less, in a sense, worried about the large firms who I think got on the bandwagon 10 years ago, but my concern is with the medium and smaller firms where not only, I think statistically I'm right, the majority of Ontario lawyers reside, but I also think that is where the majority of racialized candidates are going to, because in an incredibly competitive economic environment, it's incredibly hard to get into any firm, let alone the large law firms, but we're looking for opportunities anywhere. So my pitch is obviously the small firms, medium firms, we've got to do everything we can to make that happen. And one small suggestion, we've always done this at our firm, is just standardized interviewing. The partners get together, we have our list of 9 or 10 questions. We make sure that the questions don't violate the Ontario Human Rights Code. We make sure the questions are not going to skew towards a particular gender or a racialized demographic. So there are no golf questions, right? There's no cottage questions. They're questions about, they're easy questions. What do you do for fun? Why did you choose our firm? What do you know about our firm? Fairly standardized. And I've always wondered why all firms don't have standardized questions, because these opportunities where there's tremendous discretion is exactly where racism, sexism reside, right? When you have those purely discretionary questions,
Right.
that's what happens. So these are just very well-established ways to avoid, avoid traps, which are, people are well-intentioned, but that's where they fall.
So in government, our questions are standardized. It's like you have to do a law school exam to get through our interview process. They are standardized. And the other thing that we do is we try to make sure that the panels are also reflective. So it's not one person who's doing the interviewing, it's usually 3. And I know it's a bit intimidating, but anyway. But, we try to have a racialized person, we try to have gender balance, etc. To avoid bias, or unconscious bias often, right? And the look for fit as defined by whom, right? So if you have a diverse panel, then you start to move away from that kind of, so-and-so is not, sort of mag-like or so on, right? And you begin to see other people as, they can belong, right? So that's the difference.
Sorry, I was just going to say, I think that's a really good point. I think all organizations who want to tackle issues of diversity have to look at the hiring practices. And you have to, whether it's you standardize questions or you just have lessons for the people that do the interview. So you move away from concepts of culture and fit, right? Because that's what really creates the homogeny. So, I don't want to go to a bar with them. Well, that's irrelevant for whether or not they're going to work here, right? What's relevant is, are they a good lawyer? And that's what you really need to make sure you do, to make sure that ultimately the firm will then be hopefully more reflective of the community it draws from.
There is no doubt that several organizations, including yours, have made great strides in erasing some of the inequalities, or trying to. But the fact remains that there is a problem. I want to read out a quote to you, and I picked this up from one of the responses to the consultation paper, and it really saddened me. I'm going to read it out. It said, "The right fit meant that the individual was able to talk about certain topics, including sports such as hockey, golf, or skiing, home renovations, travel to European or hotspot destinations such as Antigua, etc. The right fit meant that an individual needed to swear a little bit, but not too much, speak without a foreign accent, and not too much political correctness, and drink or let people think that they did. It meant that we were able to dress in a certain way and not be too religious. It meant we couldn't display or express offense to comments that we found painful. Instead, trying to train ourselves to laugh at them." This deeply saddened me, and it kind of confirms that we need something more than individual organizations and law firms taking steps of their own accord. Do we not need to be regulated? Anybody?
Absolutely. This might be an opportunity to tell you what they're doing in England and Wales. So, it's a split bar in England and Wales. So it's the solicitors bar in England and Wales. Since I think 2009, they have something called the Diversity Charter Annual Report, which I'm told is a mandatory reporting requirement. And what it does is it sort of gives registrants a red, green, or amber signal indicating their level of achievement within sort of a diversity inclusion framework. Now, there are no, from what I understand, there are no, that you have to report and you have to sign up, but I didn't really understand the report to go so far as to say that if you are on the lower end or the red mark, there's going to be some adverse consequence to those firms. But what's remarkable to me is that 239 of those firms have been reporting, and they break it out between 25 or less members of a firm is a small firm and anything more. But 239 firms reporting year after year, we can track the statistics. That, to me, is something that is started in another jurisdiction. Also, there's something called the Black Solicitors Network League Table, an incredible 70-page glossy magazine which year after year reports on achievements and diversity improvement, inclusion improvement. And to me, the key point was their regulator had started this process earlier. We can all have debates as to whether how far mandatory reporting should go. Just for the record, I'd never be one to suggest that some sort of regulation includes quotas, but I do think there's a huge role for a regulator to play.
Okay, so let me ask the question, should organizations be required to report on demographic data? I know this is...
I'll jump in. So my view is they should not, but I do very much advocate for organizations to do it. I think organizations, firms should do it because it shows a commitment to diversity. But again, I think if it comes from the Law Society, you'll have a very different effect. I think just to address, the point that you raised earlier I guess I'd be naive to say I can't believe it happens. I'm absolutely sure it happens on many occasions that people feel like they need to change who they are in order to fit into an organization. But I would say that organization is not getting the best from that individual, and that organization really needs to look into its HR practices to figure out what's going on, right? Because I think when you have people that feel they're not part of your firm, then you're going to have employees that are not invested in your firm. And you're not going to get the best work out of them. You're not going to get their true perspectives, which means you're not going to get the benefit of the diversity. So that's scary. But so on the other side, I would say I absolutely think there's a role for keeping track of numbers. I'm a huge advocate for it, but I think an organization has to feel that it's doing it because it's the right thing to do, as opposed to it's doing it because the Law Society is requiring them to do it.
So can I jump into that? I think that's going to be difficult to get organizations to feel it's the right thing to do. I do think, though, you do need some kind of reporting on numbers, because unfortunately this whole debate has been animated by anecdotes. And I think now we do need to move into the next phase of what are the facts, right? Is it really this low in large law firms as opposed to, the sole practitioners? I think probably yes, but we can't point, even in this debate, we can't point to numbers and percentages and so on and build from there. And this, if we don't move to some empirical data and evidence, we're going to be having this kind of discussion 5 years from now. Right?
But Malliha, I'm going to disagree with you that we don't have the empirical data, and I'm sure you've also read the report, but the Law Society does, I have it here, it's called a snapshot of lawyers. The statistics are pretty reliable now because there's something like 77% of self-reporting is going on. As to self-identifying factors, we know that there are approximately 17% of racialized lawyers in general in Ontario. We know that it skews heavily towards younger lawyers, depending if you look at the South Asian bar or the African Canadian bar. The younger you get, the more racialized lawyers. All those statistics.
But it's a snapshot, right?
No, but it's a yearly snapshot. It's been going on for since at least 2011 or 2012.
Right.
So you're right, more information needs to be done, but I don't think we're lacking a certain amount of empirical facts as to what the nature of the problem is. There's a gap between the availability of within the population and the labor market force. There's a certain number of racialized lawyers, and then I can tell you, because I was looking at this last night, that for instance in large firms, small firms and medium firms, you have sort of up to 20% of racialized lawyers. Large firms is down to 9 to 10%. So
But where's
the
the
larger it is,
accountability, right? So because you have general data, but if it is not sufficiently particularized, what's the incentive? So we're saying, oh, all large firms are not good. Well, maybe one or two are really good. So what's the point of having sort of clumps?
aggregated data.
Yeah, I would call it clumps of information, right? Yeah.
It'll be interesting to see. So it would also be interesting to see how people self-identify.
Yes.
One of the things that we've noticed is, unlike the typical conversations, racialized communities, people forget that racialized communities are made up of individuals who all view themselves as, believe it or not, separate individuals. And so, all these great things that we've rolled out that we thought was great. So 1 out of every 3 mentors for someone from a racialized community should be someone else from a racialized community, so they can talk to them and mentor them about, issues that would be common to a racialized community. And then someone would say, no, what do you do? You're looking at me based on my color. I want this person because that's a really good mentor and it should have nothing to do with my color. Whereas, then a next person from a racialized community might say, no, that's exactly what I want because I want someone who shares experiences with me and cultural commonalities. But so one of the things, so I do also wonder what will happen if it's a law society decree to say, okay, everybody identify your background. And we're Canadian too, like what is our cultural background? Right? Like so many of us have we come from multiple different cultures that it's difficult for us to self-identify. I'm from a Caribbean background, right? So, culturally, do I identify with my color? Do I identify with my culture? Like it's, and this is Canada.
But it's not an impossible task. I mean, there are methodological challenges which are well documented in the racialized report, and no one is doubting those methodological challenges, but at the end of the day, no matter how you slice it, there is a disparity, there is a problem, and it relates back to, from my perspective, just legal compliance. It is the Human Rights Code that says we ought to be treated equally, and then looking at it from a more optimistic, positive point of view, there's just, you're not getting the best lawyers out there because we're still operating in a world of fit as opposed to hopefully merit.
And here's the thing, Wesley, you said that organizations should report because it is the right thing to do. Well, I mean, organizations which do not think it is the right thing to do to report demographic data, I think they should be singled out and they should be required to share this data because I would be concerned about organizations such as those.
And wouldn't you rather know about those organizations? So let's say, we've got 200 firms in Ontario and people start moving towards actually doing surveys and determining what so they do a qualitative and a quantitative analysis. You will then know the firms that are reluctant to do the quantitative analysis, right? And I think that actually is information about that firm. I think it's useful information for clients. So for example, when you've got a BMO or an RBC or something, going out to law firms saying, we'd like to know your numbers, and there are firms that are hesitant to give them the numbers, I think that's great. I think they should know that information because it says something about that firm's culture. So I agree, it'd be great. And another concern that I have is just how long did it take to get us to this point, right? I can imagine if we say, okay, the next thing we're going to do is create a program that requires firms to disclose numbers. How many years will that be? So now we're taking the conversation, we're delaying the underlying conversation that we need to have for years while we try and do, these administrative tasks to get us somewhere where we can begin the conversation. But I think that conversation we could have had 10 years ago.
It's a very interesting comment that you make, Wesley. But isn't it true that most firms do not want to report on demographic on demographic data. And so where does that leave us? And I want to hear from Manny, because I know that BMO has been a leader in getting firms to divulge their numbers. What's your perspective?
So one of the things I want to mention in this lively debate too is that sometimes I think there can be resistance from the firms to disclose their statistics, but I think the resistance sometimes is that they're embarrassed. They think we're going to have a terrible percentage compared to our, a firm that we compete with, and we're going to look like fools. And I think part of the job of which can be the large organizations who might ask for, request such diversity statistics, but also the Law Society, is to share the purpose of that disclosure. And it's not necessarily for public shaming purposes. It is more for tracking purposes. And I think it's a long-term goal. It's not to say we're going to take the snapshot and you guys are at the bottom of the list and you guys are at the top of the list and you guys win the diversity awards. It is that we want to see where you start with. It's a benchmarking exercise. We want to see where you are in 5 years' time. We want to see where you are in 10 years' time. And you can use this data in order to benchmark your performance and demonstrate to both your peers, to yourselves, to the candidates that you want to hire, that you are improving your own diversity initiative. So I think that's one key. It's more of the communication of the goal, not to say, again, that is public shaming, but it's more to help you being the firm, to change your own internal policies, practices, identify where there might be problems. From BMO's perspective, I think one interesting statistic that I want to share with everyone is when we first started with this initiative of requesting the diversity statistics from our legal suppliers. In our first year that we started this program, we had, it was about 34% of the firms had some sort of formalized process for the collection and disclosure of those diversity statistics. After a year, when we followed up and continued on with that process, again in the RFP process to request such information, we got to a 97% rate where firms were saying we have now instituted some sort of formalized process. So part of it is, I think, if you share with them the reasons for the disclosure, they're not going to feel like you're trying to catch them in some sort of gotcha or aha moment. It is, we're working with you, we're partners in this. Part of it, BMO's reasons for requesting this type of data is we want to find firms, we want to work with firms who share our core values of diversity. And I think that's the key with a lot of organizations that are looking for legal suppliers.
Andrew, how does this work with smaller firms where you have a smaller number of people?
It's so I think one of the trickiest questions is going to be is if we're going to have sort of a compliance-based regime based on law firm size, law member size, what is that number? And different, I'm a sort of civil litigation and workplace lawyer, and there's lots of examples within workplace law where there's compliance regimes. So for instance, under the Occupational Health and Safety Act, if you're 20 or less, you don't have to file for certain things. If you're 20 or more, you do have to apply. Under the Accessibility for Ontarians with Disabilities Act, you do have to maintain certain measures, but then you don't have to file if it's 20. So there's some magic around the 20 to 25. I note, for instance, in England and Wales, you're considered a small firm if you're 25 or less, as I mentioned before. But I think whatever that number is, I think that this idea that you measure, you track, and you can do it for your own purposes or for showing to others or to the public that you're making progress is really, really important. And it's not like it's not being done already. So to share with you some information, the Canadian Centre for Diversity and Inclusion has a huge project going on, started in 2014. It'll terminate in 2016. It's partnering with the Canadian Bar Association. The Law Firm Diversity and Inclusion Network, which many of you may be familiar with, has initially signed up with 16 firms, large firms, in 2012. And I think that's grown to about 20 firms. That's going to be more at the large firm level. Legal Leaders for Diversity, which is also an affiliated group in the Corporate Counsel Department. Basically what I'm saying is for the last 5 years, there are non-regulator organizations that are already tracking this data. So it is happening. My pitch is for it to decentralize, to have a regulatory component within the Law Society. And long-winded answer to your question, I think small firms and medium firms should do it. And I'm also heavily suggesting that the Law Society should make it mandatory, because for firms like mine, if you just make it voluntary, we've got so much stuff to do, we're not going to get to it. I mean, in a small firm like mine, where we have 3 partners, any one partner at any one time is working on our website, marketing, retention, keeping our associates happy, doing the work. You know, there's about 4 hats any one of us wish to wear. Without regulation, it's just not going to happen.
Right. And other than just following or tracking the number of racialized individuals in an organization, is there any other statistic related to diversity that ought to be tracked or are tracked in your experience?
If I can jump in, yes, it's not just, that's what I was quarreling with, one of the things I was quarreling with earlier. It's not just the numbers, right? It's what happens to them after they're in. And, you know, I think when you look at diversity statistics, it's just not, you know, as you said earlier, Wesley, it's not like a racialized lawyer is a racialized lawyer. It's like you've got to cover the spectrum, right? And then what happens to them in the organization? If all racialized lawyers, I think the report does mention this, right? Many of them don't make partner. That's a problem, right? Or if they all stagnate, you know, at a certain level and then can't get the famous glass ceiling analogy, then, you know, those are indicators of an unconscious bias type culture. So I think you do need to track the life of these people who enter, and if there are barriers, then you need to look at what those barriers are and why, right? Because as you go higher and higher or get more senior, you know, there are different, shall we say, clubs that form, and can people from different backgrounds get entry into those clubs?
Yeah, I think that's a great point, because you do see it, and you see it in all organizations, right? Even the organizations that are telling the lawyers, oh, you guys are so bad, look how diverse we are. Well, look at your upper echelons of your management. Right. And so, you know, one interesting thing is Walmart actually does a really, really good job of doing an analysis of their external counsel, to the point where they actually want to, because, you know, they have quotas. They actually say, we need people of diverse background working on this. And then in the last couple of years, they've gone back and they've said, not in Canada, in the US, they've said things like, okay, we want to understand the profit scheme for these individuals, because you're presenting these lawyers from diverse backgrounds who we understand are performing the work. Are they getting the points from this? So they're actually going to the partner pool of some of their big law firms to say, and specifically for black lawyers, they say, I don't think that there's a correlation between the work that they're doing and the representation that we have and how much these individuals are getting remunerated. Show me why I'm wrong. Which I think is brilliant, but and has really helped, you know, certain communities in the U.S. Walmart's been quite a big leader. There's an organization called the MCCA, the Minority Corporate Counsel Association, and they have a conference every year, and you'll have the best anecdotes of things that are happening in the U.S. From. They do have wonderful parties.
It's amazing how many different initiatives there are, and Andrew was talking about it. And wouldn't it be good to be able to centralize or to bring together all of these initiatives, which brings me back to a question I asked earlier, which I don't think we've done justice. Should the Law Society be involved, and in what capacity? As facilitator, as you know, the regulator with a proverbial stick?
You heard my answer already.
Yes.
Yeah, I question how effective the Law Society will be. And if you have a stick, what is that stick going to be wielded over? Right? You don't have enough diverse people. You know, this law firm that's located in Bracebridge, Ontario, has no diversity whatsoever. You're bad. Well, let's look at it contextually, right? How many applicants do they have? Do they even have an option to have diversity?
But you are bad then, right? You go up Bracebridge or take it up Kenora, for example. We've got a law school up north. I mean, we've got a big Aboriginal population. They should be diverse, and they should be held to account now. But I kind of agree with you 50% in that this is a very important initiative, and it's a society-building initiative. And leadership of it has to be earned.
Right.
So it should not be a mantle that is just handed over. So then I go back to, so you'll be obviously looking for leadership, and we have to say, well, why this group and not the other? So those, I think, those are the questions.
I was going to say, I think in terms of Law Society's involvement, I don't think there's one tool that they should be using. I think there's a whole spectrum of tools. We've talked about a lot of them. There's there's the carrot, there's the stick, there's comply or explain, things like that. And I think every different types of initiatives may merit, and also different types of the target, whether it's a small organization, small law firm, large organization, they may merit a different type of incentivization. So something like a mentorship program, where we want to ensure that maybe even one of the areas we haven't talked about is foreign trained lawyers, and I think that's certainly very well represented in the consultation report. A lot of the foreign trained lawyers don't understand a lot of the resources that are out there, and aren't even made aware of the resources out there to know what can help with their career and how to further their career. And so maybe we need to institute, maybe the Law Society could take advantage of their powers and institute some sort of mandatory mentorship program for those firms that take on foreign trained lawyers, and also provide some sort of incentive to take on foreign trained lawyers. So I think there's a balance to everything. I do agree that ultimately disclosure of statistics is very important. I'm all for that. But how to do it, whether it is making mandatory the firms to disclose it, or making mandatory that they create some sort of process, internal process to collect the data, and then the disclosure maybe comes through another method. I mean, there's softer ways, there's a whole spectrum, I think. And so I think that's what the discussion also needs to be. So I kind of agree with everyone on the panel and no one else on the panel. So I think it's somewhere out there, and I think that's what the discussion, I think that's what the challenge that the Law Society faces right now.
Right. One of the questions that the Law Society has thrown out is how to enhance the profession's cultural competencies through continuing professional development programs. Do these help?
So just to be consistent, you
don't have to be consistent.
No, but I find, I have to say I'm sort of a little bit surprised at when I've thought of this topic for the last few weeks and few days, I've seen a certain, I feel that, and part of it is my experience from being involved with the Law Society. So I was chair of the Equity Advisory Group in like 1999, 2000. And so the debates that I'm hearing today have a familiarity for me, because keep in mind, in those days, in the early, Malliha, you know what I mean, we were having debates about whether we should establish Discrimination and Harassment Council. That program has now been around for 10 years, and thanks to that program, we can measure complaints made about discrimination and harassment in law firms. We were having debates as to whether the Law Society should even have model policies. We now have them. We were having debates as to whether the Equity Advisory Group should exist. We were having debates as to whether the EAC, which is the Aboriginal and Equity Initiatives Committee, which is a group of benchers, should exist. Were it not for those organizations, we would not be having this debate today. So that doesn't mean that everything always skews towards more and more regulation, but the perspective that I'm coming from is that what feels very, somewhat coercive and a big step actually isn't from a historical, evolutionary type of perspective. And that I think, for instance, in the area of cultural competence, if you took 1 hour, I've seen somewhere in the racialized report some support for taking 1 hour of professionalism training, or adding to the 1 hour to the 3 hours competence about exposing your average lawyer to what does cultural competence mean, what does anti-discrimination mean, what is the meaning of racialization. Racialization is a social construct. I mean, that in itself would go an enormous way to educate that lawyer in Mississauga, Bracebridge, Windsor. That's not something we have today.
Or is it going to be seen as as an annoying kind of checkbox that you have to tick?
Right, if they're not invested in it,
Yeah, as you
are
said.
they going to see, because again, you take it out of the context. So should the context be, you really should get this training because we have a more diverse community, your clientele is more diverse, you need to understand cultural competency in order to better represent your clients and better understand the issues that you're going to face? Or do we sell it as, you've got an hour of CLE, watch it as you do work and sit in your office? So
I guess I was going to say, I guess that's partly how we feel already now with with our CPD requirements. But to go back to something that Andrew was saying, I think a lot of
December is a very busy time.
But one thing Andrew said before is that we were talking about the importance of this report, and Andrew made the very good point that may not be important to those of us, all of us who sit in this room, who already know that this is an issue that the profession is facing. But to those individuals, to those law firms which is predominantly white, predominantly male, who may not see this as being an issue, maybe they have one racialized licensee in their firm, and they think we gave them an opportunity and they should be grateful. But they don't realize that there's the unconscious bias that Malliha has talked about. I think CPD can open their eyes to some of these things, and some, unfortunately, a forced CPD, but I think it can be a targeted CPD as well. So unconscious bias training, which we do at BMO for many of the senior leaders, and it's trickling down as well. I think that should be made mandatory in terms of training for lawyers who are in hiring positions, who are either named partners, those that have influence. I think it's also a great seminar for all people involved. I think that's the whole key of unconscious bias, is none of us know that we've got it.
I think it has to be a must these days to have CPD on cultural competencies, because I think it's a business requirement, because we now take it, say it's a large firm, government, or medium-sized firms. You're always dealing with people from diverse backgrounds. You cannot avoid it anymore. There's the global village and all of that, and one will, as a lawyer, will have files that deal with people from different cultures, right? Even in a small firm, in the family law practice and so on. How can you give good legal advice if you don't understand the cultural context from which your client or that file comes from? How can you possibly do that? Now, you would think, actually, I realized this most recently, just a few weeks ago when we were handling a file. It was obviously a file relating to another country, another religion, and another culture. And all of a sudden, we realized that we had not understood what this file was really about. And that was because we were missing the cultural competencies related to the matter at hand. Right? I mean, we caught it, right? But it was, if we had not, in my view, that would have been negligence. So
Right.
I think it's not something nice, it's a necessity.
I think, isn't it important to think about who the cultural competency programs should be directed at, and depending on who they're directed at, they should be different? So, we're hearing some of the same themes over and over again, that leaders have to be invested in diversity and diversity initiatives. So should there be CPDs specifically targeting people in senior positions, as you said? But then again, Malliha, at the start of this discussion, you said, well, if there's a force at the top, it has to be matched by a rising, kind of an equal opposite force from the bottom up. And so should there be CPDs tailored to what stage you are in your profession?
Well, and and again, I'm a huge proponent for things to be contextualized, right? So as part of our cultural competency, we even talk to people about being on the phone. So people from different countries and different parts of the world have very different phone manners. And, you know, in certain parts of sub-Saharan Africa, if the weather is the same every day, or if you're talking to certain people in certain parts of Europe, you do not ask them, how's the weather? Because it's the same.
We
It's
just
the dry
had that
season. It's the wet.
conversation.
Yeah.
Yes.
So, and it's also important, again, in our organization, we deal with people from all around the world. And different people have different manners of speaking. So, for example, East Asia, you do not, you know, in the West, it's very uncomfortable if there's ever silence. Right? If I'm talking to you and you're not responding right away, it's so uncomfortable, and someone better fill that in. And if you're dealing with clients from East Asia, oftentimes the expectation is there better be, you are not thinking about what I am telling you if you start talking as soon as I finish. So I think cultural competency is extremely important, but I think it's extremely important to learn it in the context of how it's going to relate to your practice. And I just have a feeling if the Law Society rolls out a cultural competency 1 hour CPD, you know, how, is it going to be useful to anybody? I'm sure it will be.
So, so do you think there's room for other organizations such as SABA, FACL, CABLE to fill in the void?
Absolutely.
Yes.
I think they've been great.
yes.
We've been drawing on CABLE for mentorship and a number of other, you know, adjuncts to our own programs for a while now.
Right.
So this is what I've been saying too. I think those organizations must do it. I'm not a proponent of, you know, one sort of big, you know, organization that's regulating everybody to death, and it may be a good thing, but I personally will rebel against it, right? So that, and I would think all the lawyers at MAG would too, because we are trained to rebel, right? So it's much better when other organizations that already have legitimacy and credibility, and this is the other thing I keep coming back to, are the voice of racialized people. You know, it's got to come from within. Because you can regulate as much as you want, it'll be like those CPD hours, right? Unless it's from within as well, it won't happen, right?
Is there a fear that, you know, if SABA, for instance, is assisting South Asian lawyers, FACL, Asian Canadian lawyers, there's a ghettoization that might result?
I think you have to look at that, answer that question in a historical framework, because I think in the evolution of any social movement, the LGBT movement or gender or anything, there is a time and place for sort of what I call ethno-specific or specialized organizations. And I have, and you have seen sort of the incredible rise of FACL or SABA that does a number of things. One is that it becomes sort of a bit of a clearinghouse of information for the members themselves, but also is looked to as a bit of an ambassador from the larger community. So to give you an example, one of the things our firm does is we generally sponsor a table at the SABA event, because I'm of South Asian origin, and I will often bring different people to that table, and I will often have them say, I'm talking about white lawyers, mainstream, you know, senior partners who will say, oh my God, you know, this South Asian bar is like really, I've never seen so many talented South brown lawyers. And I'm like, well, we've been here for a very long time. But they're being educated about it through the platform of a SABA or a FACL or a CABLE, and that is the stage at which we are at, and it's necessary to sort of focus, centralize some of those efforts. So despite everything I've said, I would never advocate that the Law Society is the only place. I mean, far from it. I think we all need as much to go on as possible, and Dean Lawrence Austin of Osgood Hall has written an excellent submission to the Racialized Project where he talks about partnering, he talks about the as you said, where the voice has to come from. But it is exciting to see a RODA or you know, these other organizations, OLA, the Spanish lawyers, the Iranian lawyers. It's incredible what a proliferation there is. It's happening relatively recently in the last 5 to 10 years, but it's a reflection of demographics, and it's a reflection of the greater confidence that many racialized lawyers have
Right.
to assert their own voice.
Yeah. And I think there's also something to be said about mentoring and networking and using all of these networks to do so. And that said, racialized lawyers should not only be hobnobbing with their own kind for the reasons we've discussed, but there should be like a wide-ranging list of organizations where racialized lawyers are given the chance to interact with lawyers from different communities. Do you think that the Law Society has a possible role to play in this?
The Law Society is already doing that to some extent through EAG, which stands for Equity Advisory Group. For over 10 years, EAG has been a group of individuals from diverse organizations that sit in one sort of administrative and shared space. They have meetings, they interact with the benchers, and that group has brought a lot of information to benchers, and the benchers bring information to that. And now I think that I mean, it's nice to see other organizations like RODA, which is the Roundtable of Diversity Associations, take over that role. But absolutely, I think the Law Society, in particular, the Equity Initiatives Department, in part through events like this, and we're focusing on racialized lawyers, but they do that for other events, public events, whether it's International Women's Day or the Pride celebration in June, or Holocaust Memorial Day, or Aboriginal Awareness Days. So I think that was an important step in bringing the attention to the fact there are all kinds of different lawyers out there, which I think isn't, until relatively recent, wasn't always known, let alone celebrated.
Right.
So I'm just going to do a counterpoint. So I think mentorship is incredibly important. No matter what your profession is, it doesn't matter what your career is, having a mentor is incredibly important. And I think that mentor has to be very invested. It has to be a sponsor. Like sponsor, there's discussion now about mentorship versus sponsorship. I think in order to be really successful, you need a sponsor. And my concern about Law Society programs, and I've acted as a mentor, I don't know if it was through the Law Society or another way, but you get these connections where you're told to meet this individual. You kind of just meet them as you have this conversation. Usually there's a few of them, and you give them some tips on how to be a good lawyer. I'm still trying to figure out. And that's it. And you may continue, but it's kind of the stunted conversation. Whereas if you establish these relationships through organizations like SABA, right, or like FACL, or any of those, you meet them on an annual basis. You really get to know people. You've got commonalities, and it's not that your networking will ultimately be limited to just those individuals that you meet at those conferences or what have you. But you'll establish, hopefully, one of those sponsorship type relationships that will take you much further than it would if the Law Society were just to pair you up, I think, with someone who, on paper, seems like a good match.
Well, I see that we've almost neared the end of our time for the discussion. Now, before we open this up to questions, I'm going to invite each of our very, very distinguished speakers to give us a little sound bite on a message to the profession, to the Law Society, what have you, on what the next steps you think should be. And it's probably going to be a summary of what you've already said, but starting from Malliha.
Okay, so I think the next step has to be, and this is actually quite different from what I thought 3 or 4 years ago, is that we have to start collecting empirical data. So data which tracks, which has an accountability factor attached to it. Because that is the only way that we will be able to move the debate forward.
Cultural competence is part of CPD. Mandatory demographics with some context for size of firm, and far more attention on just choosing 2 or 3 programs that'll work rather than, spinning the wheel about, wringing our hands about whether, racism exists. And because we've done that, everybody, we've now got this report which says that 83% of racialized lawyers think there are barriers. 63% of non-racialized lawyers think that there are barriers. So we've kind of done that, and let's move on.
Right.
I would say if racialized communities acknowledge, and I'm sure we all do, that there's an issue out there, I think it's incumbent upon people from the racialized community to address that issue. So I would say, we might disagree on how we address it, but everybody in this room, if you think it's an issue, you should be active in trying to address that issue.
It's always worse to be last because I agree with everything that everyone said. I do want to underscore the importance, and I'm a huge proponent of the collection and disclosure of statistics, and I think the Law Society has a role to play in that.
Well, thank you. I want to thank our panelists for sharing your time and sharing your amazing insights. And we hope that we've given the profession and the Law Society lots to ponder on. And let's hope that the next time we have this discussion, we're much, much further ahead.
We're opening it up for questions now. So if there are 3 mics, if you could go up to the mic and you can address everyone or address one particular person. There are mics on the floor. If you would just line up behind them and pose your questions.
Working. So my suggestion is that in terms of accountability, the Law Society has to take the leading role, and the annual report, which all of us are required to submit, there should be made changes into that. And in terms of hiring of the racialized lawyers, there should be a component of that how many lawyers in a particular area were hired and how many were racialized. The definition of racialized should also be defined as well. I think that way will be a great way to collect the data, and as Malliha said, the accountable data as well. The second thing I would like to suggest is that the CPD course about the racialized community awareness, that should also be rather made a mandatory part for about 3 to 4 years, and particularly 1 hour's course, which should be free of cost as well, so that everybody, would be inclined to get into that. Another thing I would suggest on the part of Law Society is that Law Society should also take a leading role in terms of creating awareness among big employers as well. For example, the insurance industry, because I do in personal injury claims, I am also, because I am not still a full lawyer, I have written my barrister, which I luckily passed, and the solicitor I have to write. So quite a few, months when I will be a full-fledged lawyer. But since I am an NCA lawyer, I see that the insurance companies are all filled with white people. Now, when I am doing the discovery, when I am with the lawyer and doing the discovery, me and the lawyer, we only are non-white. The adjuster is white. The defense lawyer is white. And if we are doing mediation, third-party mediation, I mean, mostly the mediators are also white. So where do I stand? Now the challenge is, this is the real challenge, which, as a personal injury practitioner, I am facing in real life. I can give you stories about this as well. It's not like that, I can give you stories about that. Sometimes, when we have a very strong case, some white lawyers even chasing us. Now what kind of this attitude is? And show me, a single law firm, defense law firm, where I have yet to see a single racialized lawyer on the defense side, yet to see.
So, sir, can I ask you what your name is?
Sayyid Raza.
Sayyid Raza. I think you will be happy to know this. I'm on the defense bar. I work for Zurich Insurance Company. And sir, thank you for sharing your comments, and I look forward to meeting you on the other side of a discovery. Thank you so much.
Yes, sir.
Go ahead, sir.
Is it my turn?
Yes,
okay,
go ahead.
Thank you. I would like to convey my appreciation to the organizers as well as my gratitude and commend. I highly commend the panel speakers. Their observations and comments are very relevant and useful. On the other hand, I would like to add another dimension to our today's discussion, which is this. In addition to racialized lawyers, there are also racialized paralegals. And what is more important is that racialized paralegals, in addition to this racialized issue, they also face additional barriers to enter or remain in the profession. For instance, in terms of their career advancement. And I would like to hope that maybe in our future events we can include this dimension as well. By the way, in Ontario, we have an OPA, Ontario Paralegal Association. And within that association, we have many racialized paralegals. And we also have initiatives targeting the racialized, to serve the racialized communities. So that's my comment. Thank you.
Thank you, sir.
Is it my turn or are we going in
Oh,
consecutive?
I'm sorry, am I up?
yeah. The gentleman first, followed by
Number 3, I guess,
Yeah.
sorry. Yeah, so this idea of mandatory reporting by regulation is not as radical as people here think it is, because I'm not sure if there's any other securities lawyers here, but I think since last year, the Ontario Securities Commission, which is one of the largest regulatory organizations in the province, or if not Canada, is already requiring mandatory demographic reporting as far as women are concerned. So to better represent women on publicly listed companies' boards, every publicly listed company in Ontario has to report on an annual basis the number of women on their board of directors. And it's not as if they're requiring quotas in terms of you have to have X number of women on your board, but what they are requiring is for publicly listed companies to report the number of women on their board and also what policies they have in place to encourage better representation. So we shouldn't be so timid in thinking this is such a radical or onerous requirement. It's already there. And the Law Society is a regulatory body just like the OSC. And if there hasn't been much pushback or revolt against the policy by the OSC, I don't see us lawyers pushing back against the Law Society for implementing something that's already in place. So that's all I want to say.
Thank you, sir, for raising that comment. I can assure you that we, organizations such as SABA and FACO, were following that development closely. And it is, in fact, our position that a similar comply or explain regime ought to be instituted in the profession. So hear, hear. Okay.
Okay. Thanks. So I echo the gratitude and complimenting of this event, but I also do want to congratulate or point out the fact that it's wonderful that these events are being opened up to people who may not be lawyers. So I self-identified in my registration as a member of the public, but I'm actually a legal assistant. And before I ask my actual question, because I do have a question, I want to point out that at least at the firm where I've worked for over 20 years, I have seen an increase, a tremendous increase in cultural representation, in racialized diversity, but it's been at the staff level. So what I've seen is that assistants and accounting staff and mailroom staff and copy center and all at those levels, the racialized workers have become better represented. And you know, essentially, this is really at the heart of or it's certainly relevant to the issues that are being discussed, because we hold the positions that are lower paid. We hold the positions where there's no power whatsoever. So I think that, you know, that should be part of the conversation as well. But my question is how we promote the kind of how we promote the importance of the issues that we're discussing without appearing to be self-serving.
That's a very good question. Who wants to take it?
I guess I'm not quite sure I fully understand what you mean by self-serving, but if you're suggesting that it's self-serving for racialized groups to say that this is an issue, and I have often grappled with the fact, for instance, that it seems always incumbent upon racialized people to make the pitch for greater diversity, but that's no different from any other progressive movement. I mean, it wasn't men that were arguing for the emancipation of women. It wasn't straight people arguing for the rights of LGBTs. It has to start somewhere. We feel the pain. I mean, you know, when I came to this country, I was called a Paki and punched in the head for no other reason than I was brown. I mean, many of us have stories like that. So when you feel the pain, you're going to advocate for yourself. And for those of us lucky to have an education, and some of us became lawyers, we're going to continue advocating for ourselves. So, I mean, but I think the political question is an important one that you raise, that there is always this sense that in addition to just being a lawyer and having to do my job, I now have to sort of advocate for my people, you know? And that is not something that I would ever say that everyone has to wear, but for those of us that can speak out and do understand the issues, I think no one else is really going to do it. No one else is going to do it as well, as articulately, or as authentically as you can. But it is really important to get other non-racialized people advocating with you. And I think, I'm an optimist, I think that many non-racialized people get it, maybe not fully or as well in different ways, but I mean, we're there in terms of that recognition. So you're going to have to, you know, you're going to have to fight, we're going to have to fight our own battle to some extent, or lead that charge. But there are allies. Every movement has its allies, you know, and that's a greght thing.
And if I can just add to this, because I was actually having a conversation with Manny about this on the way here, where what you said is actually, I've heard it from a number of other colleagues, and oftentimes it will relate even to specific communities, right? So someone from a specific community will feel that there was an injustice, but they're reluctant to raise it because they think that it's self-serving. And I think in many cases we create those barriers ourselves. And I'm sure I'm naive, but I'm a huge advocate for just talking, right? Because ultimately, if you're raising a concern around racialized diversity in your firm, it's something that's going to help your entire firm, and I think people will appreciate that.
And that's why I think, to your point, why this report is so important is that it was created by the Law Society, or it came together, the working group, and as we said before, it was predominantly represented by, you know, white males. So the fact that they recognize that there's an issue, they've put it into a report. We'll see what they do with the report, which is important as well. But I think it's a great first start. One little anecdote I had too is one of the early consultation sessions, which they opened to the public, the Law Society had a whole panel. And I had attended that session here in Toronto in this room. And the whole panel was all white. There was male and female, but it was all white people. And afterwards, people kept making the very important key comment that why is the representation of people who are, you have the people representing the Law Society discussing this report, why is it all white males and females? Why isn't there some additional representation? So I think they've gone a long way, but there's still a lot of ways to go, and that's where I think we're all watching closely.
Okay, so we've got 3 people who wish to ask questions. This gentleman here, then Ms. Ma at that end, and the gentleman in the middle.
be quick, I promise. I know none of the members of the panel are actually part of this demographic, but I wonder, as we talk about solutions, what your thoughts are on the role of sole practitioners. Because I think, are we prepared to cede that perhaps they're not part of this solution because by their nature they're on their own? Or do they have some kind of role to play and the Law Society with them in contributing to the effort to make this a more diverse profession?
So I'll take a shot at that because I was a sole practitioner for a number of years before I joined a small firm, and I'm still part of a small firm. And so no, absolutely. I think people in sole practice, and there are many racialized lawyers in sole practice for a variety of reasons, including racism or including just being out of the mainstream, access to networking opportunities. I think I would say, to me, there is less of a sense of an obligation, if you will, for those people to make their own firms diverse. What are they going to do about it? But I think if I can address the part of how those individuals can work together with groups. So join groups. It doesn't have to be the groups you've talked about. It can be the Ontario Bar Association. One of the things that I found most incredibly helpful when I started my own firm was to join a section of the OBA, because that automatically puts you onto a platform or a committee with people who are just interested in your subject area. And you might have been, and I was, a third year practice with, no clients and starting my own law firm. But if I was part of this executive, it just meant that I was rubbing shoulders with other people. And it allowed for some collegiality, some networking, and a platform to get, to do various things under the auspices of the Bar Association. So there's lots of, many opportunities like that.
Okay.
Oh, it's my turn? Okay. In terms of data collection, I can remember as far back as 1986, we have the Federal Employment Equity Act. All the federally regulated business like Air Canada, the banks, whatever, they have to collect data and they have to meet what's required under the Employment Equity Act. So I think this data collection thing, even in the 1990s in Ontario, I think we have an attempt on the Employment Equity Act or something like that, but somehow it didn't get passed. I can't remember. It's been so far beyond, so long ago. I'm showing how old I am. But what I'm saying is data collection is the first step for any equity that you try to achieve. It could be like what, sorry, I forgot your name, the guy from Stockman?
Oh, Wesley.
Yeah. Okay, that's great that your firm is doing it voluntarily, but I'm saying not all firms are at that level. So maybe we should look at, number of people and, all the other things that sort of goes with data collection. But as a concept itself, I just can't see anything wrong with it, okay? On another point, just as I was coming up here, this mic was very tall. And I was looking at it, I said, maybe I'm mechanically not very good at things, so I dare not touch anything. And a nice lady came and make it come down to my level. And I said, well, thank you so much. And she said, well, I understand, I'm short too, So that brings me to the second area that I want you guys to think about, and that's the power of empathy. Okay? Only if you're in the same position, a short person like her, understand how I feel when I see something that high. And I ask a question all the time, like in this year, March 21st, that's the UN Day for the Elimination of Racial Discrimination. And guess what? Just about the same time, you see in the newspapers 2 articles. One is about Obama walking the Selma Walk, okay, which is to commemorate 50 years of civil rights movement. And on the other hand, I also saw an article that I think it's called Delta Chi Alpha or something. It's a fraternity in Oklahoma or in the U.S., but it's in Oklahoma City. I think Oklahoma University. They publicly publicized a YouTube saying that we will never accept black people into our fraternity. And this is today, okay? And even the civil rights leaders were saying a lot of things have changed, but nothing have changed. So why is racism so difficult to combat? Because if you look at a lot of the science that comes out, the neuroscience that I think Manfred, right? Manfred and Malliha was talking about, this unconscious bias is very well grounded in science. That, we can almost say that stereotyping, which we do all the time, we use that part of our brain all the time, okay? Because we have to be fast, especially when information, so much information comes to us. We have to be efficient with our brain. So we use stereotyping. We put things into categories, and bang, 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 we can go on with our life. But it's also still, so it's not necessarily a bad thing, but when you apply it to how you look at people, how do you select them for employment, how do you want to be, you have buddies, you have stereotyping, and could be a very, very difficult thing to overcome, because it goes all the way to your 6th level of your neocortex. I'm going to the science now. And it becomes your belief and you cannot change. Gotcha. So, I'm sorry, am I taking too much time? But I'm just saying, why is empathy so important? If you're thinking about a CLE course of 1 hour, forget it, okay? Well, it's better than nothing, let me put it that way. you have to overcome that. You've got to understand what training is about. It's not about just raising awareness. 1 hour may be enough for raising awareness, but real race relations education, you have to start with empathy.
And I just want to say that this is Lillian Ma. She's are you vice chair at the Landlord and Tenant?
No, I'm the associate chair.
Associate chair. I'm very sorry. I knew it was a higher up than that. So she's associate chair, and she does a lot of this training. So she is a good authority on what she just said.
And I was going to say that your comments are so interesting and thought-provoking that we all look forward to continuing this conversation in the next segment of today's celebrations. Thank you, ma'am, for sharing your wonderful insight.
But I do congratulate you for this event. It's great.
Thank you, ma'am. We have time for one last short question.
It'll be very short.
Thank you.
My name is Zishan Ati. Thank you very much to all the panelists for coming and talking on this very pertinent and relevant issue. I have two questions, and I promise to be short. The first one was partially alluded to by the gentleman who asked a question before me on my left, was about solo practitioners. I think it is often forgotten that a lot of lawyers are solo practitioners, not by choice, but because they were not able to get into a law firm. And one of the reasons that they were not able to get into a law firm, and this is coming from solo practitioners themselves, is because they thought they were racialized. I would like to hear from the panelists, what do they think the Law Society can do in providing a network or support network to these solo practitioners who would like an opportunity to learn and train in a law firm, number one. Number two, a lot of discussion happened regarding mentoring, which is, as we all understand, very important. I'll just give you a personal example. I applied to be a mentee of the Law Society through the Law Society's mentoring program back in January. We are sitting in 2015 May. I haven't been assigned a mentor, and the reason is there aren't enough potential mentors to be matched with mentees. I also applied to be a mentee at Ontario Bar Association in January this year. 5 months later, no mentor. So my question is, what do you guys think, what do the panelists think about the Law Society making it mandatory for all lawyers of a certain years of practice to mentor younger lawyers or new calls to the bar. And finally, last but not the least, and this is not a question, this is a comment, I think when we come here together next year, it'd be great to have someone in the panel who is a solo practitioner, and I know you are a solo practitioner, but someone in the panel who can, from a racialized community, who can give their perspective as well. Thank you.
So there were a couple of questions. Mentorship opportunities and networking opportunities for sole practitioners. We did talk about it a bit, but the questions seem to be geared towards you.
So I mean, I think one of the concerns that I would have is where, what is the right organization for mentorship opportunities? And I guess I have some concerns about whether the Law Society as a regulator is the right fit for mentorship, because mentorship is, to me, it's fundamentally a voluntary agreement where a mentor and primarily the mentor is offering his or her services, and to somehow make that mandatory just seems to be inappropriate for the model, because you can't really be coerced into being a mentor. I suppose you could, but it wouldn't be a very good relationship. And so one question is that I would probably not look at the Law Society as the locus for mentorship programs. I'd probably look at the Ontario Bar Association, and I think it's unfortunate if the OBA has had some challenges with the number of mentors. So I mean, that's my take, that somehow regulating mentorship is not the right way to go. But having said that, whether it's the Law Society or the OBA, facilitating and getting together as many voluntary mentors as possible is certainly important. But
if I might jump in here, and you did rightly point out, I recently started my own practice, so I guess I'm a sole practitioner from last year. And in terms of networking, there are a number of things that a racialized person with a small or solo practice can do. I've built my own network of sole practitioners that I refer work to. They refer work to me. I think that's one way that sole practitioners can certainly get in and advance the cause of racialized lawyers. If there's mentorship, I would highly recommend the OBA. There's a solo, small practice, and general practice section. They have events. It's an opportunity to get to know your network of people that will be your referral source in many ways. It is an issue in terms of racialized lawyers tending to be more amongst the solo bar, but there are also a lot of people who are solo practitioners or small firm practitioners because they want to be. There is a racialized population that demands that kind of practice as well. And I think all of us will be happy to speak with all of you during the mix and mingle. Do some final words from Jayashree, and then from me.
Well, I mean, I'm just going to address everyone from here. I want to thank everyone for taking time out of your very busy schedules to come here at 4:30 on a weekday to listen to this discussion. As I look around the room, I feel buoyed by the mosaic, the cultural mosaic that is in this room and that's come to listen to this discussion. And as a member of the profession, I feel very hopeful for the future. Let's continue to work together and make this profession the best that it can be. Once again, a big hand of applause to our panelists.
Okay, and I echo Jayashree's words as well. Thank you for everyone for coming. To our distinguished panelists, you dealt incredibly well with very difficult questions, and I would like to thank you. And as a token of our appreciation for this evening's speakers, the Law Society will be making a donation on their behalves to the Toronto Lawyers Feed the Hungry program. This program fights hunger year-round in Toronto, London, Ottawa, and Windsor. and through the generosity of donors and the tireless support of volunteers, they provide meals to the hungry and financial support to charitable agencies that help with hunger relief. Please feel free to donate to them as well. On a final note, and just before we all go off to the mix and mingle, I want to echo the words, the fighting words of Andrew and Wes, and also the voice of a remarkable person, Mahatma Gandhi. Be the change you want to see in the world. Okay, let's all mix and mingle.